Utilities Commission, and joining me today are Commissioners Brown Bland, Clodfelter, Duffley, Hughes, McKissick, and Kimmerite. I now call for hearing docket number W-354 sub 412, which is in the matter of application for approval of a business combination between Carolina Water Service Incorporated of North Carolina, Corix Infrastructure US Incorporated, and SW Merger Acquisition Corp. Before we proceed further, and as I am required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any member has a known conflict with respect to matters coming before us this morning. The record will reflect that no conflicts have been identified. The intervention and participation of the public staff in this proceeding is recognized pursuant to North Carolina General Statute, Section 62-15 sub D and Commission Rule R1-19E. On November 23rd, 2022, Carolina Water Service Incorporated of North Carolina, or CWSNC, Corix Infrastructure US Incorporated, or Corix US, and Southwest Merger Acquisition Corp., or SWMAC, and collectively the applicants, filed with the Commission an application for approval of a business combination. Refer to that application as the application. Filed with the application were the direct testimonies of Donald H. Denton III, Ellen Lapson, Dante M. DeStefano, and Brian D. Barr. CWSNC is an investor-owned public utility, does business as a regulated water and sewer utility in North Carolina, and is subject to the regulatory oversight of this commission. The application proposes a transaction pursuant to which the water and wastewater businesses of Corix US and SWMAC will be combined. The application provides that the proposed transaction does not involve a change in the direct control of CWSNC and does not involve a transfer of CWSNC stock. Further, the application provides that the transaction will have no impact on the Commission's continuing regulation of CWSNC as a regulated water and wastewater utility in this state. Assuming the transaction is approved, CWSNC would remain a public utility subject to the jurisdiction of the Commission pursuant to the North Carolina Public Utilities Act and the Commission's rules and regulations. On April 25th, 2023, on the public staff's recommendation, the Commission issued an order in this docket scheduling hearings, establishing discovery guidelines, and requiring customer notice. The order scheduled a public witness hearing to be held remotely by way of WebEx on July 20th, 2023, as well as an expert witness hearing to be held in Raleigh beginning today, August 2nd, 2023. On June 30th, 2023, the public staff filed the joint direct testimonies of witnesses Feasel, Chu, Darden, and Hinton, which sets forth the public staff's recommendations on the application. On July 14th, the applicants filed the joint rebuttal testimony of witnesses DeStefano, Barr, and Denton, as well as the rebuttal testimony of witness Lapson. On July 20th, a public witness hearing was held for the purpose of receiving public witness testimony on the application. On July 26th, the Commission issued an order on the public staff's motion, excusing witness Chu from attending the expert witness hearing and allowing witness Feasel to testify regarding portions of the pre-filed joint testimony and exhibit originally addressed by witness Chu. On July 31st, the applicants and the public staff filed their joint settlement agreement and stipulation, to which I will refer as the settlement agreement, which in effect settled all issues between the parties to this proceeding. On July 31st, the applicants filed the testimony of witnesses Barr, DeStefano, and Denton, and the public staff filed the testimony of witnesses Feasel, Darden, and Hinton, all of which supports the settlement agreement. An amended settlement agreement was filed in the docket on August 1st to reflect a technical correction to the document. All right, that brings us to today. I call upon counsel for the parties to announce their appearances for the record, and we will begin with the applicants.
Thank you, and good morning, Chair Mitchell and members of the Commission. Joanne Sanford with the Sanford Law Office, appearing this morning for Carolina Water Service, Inc. of North Carolina and Corix Infrastructure US, Inc. I'm joined in the hearing room by Donald Denton, Steve Lubertozzi, who is behind us, and Dante DeStefano. I have worked jointly in this matter with my colleague, Mary Lynn Grigg, who will make her introduction and that of her client.
All right, good morning, Ms. Sanford.
Good morning, Chair Mitchell, Commissioners. I'm Mary Lynn Grigg with the law firm of McGuire Woods, appearing on behalf of Southwest Merger Acquisition Corp. Also here for the company is Mr. Brian Barr, who is Director of Rates and Regulatory Affairs.
All right, good morning, Ms. Grigg. All right, before we set forth with the proceeding, I will.
Mitchell?
Oh, I'm sorry, Miss Culpepper. Go ahead.
Elizabeth Culpepper with the public staff, appearing on behalf of the using and consuming public. And appearing with me are James Bernier Jr. and William S.F. Freeman.
All right, good morning to the public staff. And again, my apologies, Ms. Culpepper. All right, preliminary matters that we need to address before we get started.
We do have a few matters, thank you. Some organizational issues. First of all, we bring to you a proposed global settlement this morning. And we appreciate the very hard work done by the public staff and with both parties in conjunction with our clients, which have made this outcome possible. Secondly, we thank you very much for excusing witness Ellen Lapson. That was much appreciated by us and by Ms. Lapson. We will, at the appropriate point, ask to move her testimony into the record this morning. Third, the organization of our presentation today is as follows. We're presenting our witnesses, Denton, Barr, and DeStefano as a panel. We have provided summaries of their testimony to the public staff and to the commission this morning, and we have one coming to the court reporter. We will not read the summaries. They are available to you, but we will not read the summaries. Our witnesses will be available thereafter for examination by the commission, and we all understand the normal process of examination and follow-up examination. The public staff witnesses will appear next, after which we reserve the right to call our panel should that be necessary. We don't think that it will be, but we have discussed it with the public staff that if necessary, we would ask you if we could bring our panel back before you. We appreciate your time and attention this morning. Ms. Grigg will address some document issues for us if that is the right time with respect to moving things into the record. And with that, I will turn it over to Ms. Grigg.
All right, Ms. Grigg?
Is now the appropriate time?
Yes,
Chairman?
please.
Okay,
Proceed.
thank you. We would like to move the company's application for approval of the business combination, which was marked for identification, be admitted into evidence. For the record, the application consists of 20 typed pages with appendices A of 8 pages and appendices B and B, which is 175 pages, which was filed on November 23rd, 2022. And please note that a portion of Appendix B contains confidential information, and we ask that this material continue to be treated as such.
All right. Hearing no objection to that motion, I will allow it. And I note, just for clarity in the record, the application, which was filed on the 23rd of November, 2022, included 6 appendices, but for the moment, we are going to move in the application plus Appendix A and Appendix B, and Appendix B has confidential information in that appendix, and we'll make sure that it's treated as such in the transcript.
Thank you, Chair Mitchell. Yes, the remaining appendices will be moved in as the testimony is moved in later in our direct text.
Yes.
I'd also like to move the company's direct testimony of Ellen Lapson, which was marked as Appendix C to the application. We asked that it be read into the record as if the witness gave it orally from the stand. The testimony consists of 17 typed pages, 1 exhibit of 7 pages, and was filed on November 23rd, 2022. We request that Ms. Lapson's 1 exhibit, which was pre-marked for identification, and her testimony be entered into the evidence.
All right, so the direct testimony of Ellen Lapson, which was filed in this docket on November 23rd, 2022, consisting of 17 pages, will be copied into the record as if given orally from the stand. And the 1 exhibit to that testimony will be marked for identification as it were when pre-filed. And that exhibit will be admitted into the record as I've heard no objection to that motion.
Thank you, Chair Mitchell. I would also like to move the company's rebuttal testimony of Ellen Lapson. Ask that it be marked for identification and admitted into the record as if the witness gave it orally from the stand. For the record, the testimony consists of 5 typed pages and was filed on July 4th, 2023. We ask that it get admitted into the record.
Okay, let's see. So I will allow that motion. The rebuttal testimony of witness Lapson, consisting of 5 pages, which was filed on July 14th, 2023 in this docket, will be copied into the record at the appropriate time as if given orally from the stand.
Thank you, Chair Mitchell. And finally, I would like to move the company and public staff joint settlement agreement and stipulation. We ask that it be marked for identification and admitted into the record. For the record, the settlement consists of 7 typed pages and Appendix A, which was 8 pages, and was filed as corrected on August 1st, 2023.
All right, the settlement agreement, as corrected on August 1st, will be admitted into the record. Having heard no objection to that motion.
Thank you, ma'am.
Okay. With that, any other preliminary matters, Ms. Culpepper?
No.
Okay. And I assume this public staff's in agreement with the order of witnesses?
Yes.
Okay. With that, the case is with the applicants. Please call your witnesses.
Thank you. I call Donald Denton, Brian Barr, and Dante DeStefano, please.
All right, good morning, gentlemen. If you would, raise your right hands, left hands on the Bible. Swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, you may proceed.
Thank you. Good morning, gentlemen. I'm going to go through some preliminary questions with respect to your various pieces of filed testimony, and we'll go quickly. Mr. Denton, we'll start with you. Please state your name, position of employment, and business address.
My name is Donald H. Denson III. I'm president of Carolina Water Service of North Carolina, and my business address is 5821 Fairview Road, Charlotte, North Carolina.
Do you have with you a document entitled Direct Testimony of Donald H. Denton III on behalf of joint applicants consisting of a 1-page summary and 11 typed pages of questions and answers, which was filed on November 11th, 2022?
Yes.
Was that document prepared by you or under your supervision?
Yes.
Do you have any corrections or additions to that document?
No.
If you were asked the same questions appearing there, would you provide the same or substantially the same answers?
Yes.
You have prepared a summary of your testimony, is that correct?
That is correct.
And it has been distributed to the public staff, the commission, and the court reporters,
Yes.
correct?
Correct.
I'll ask that Mr. Denton's direct testimony be marked for identification and admitted to the record.
That motion will be allowed.
Thank you. Now, Mr. DeStefano. Please state your name, position of employment, and business address.
My name is Dante M. DeStefano. My position is Director of Regulatory Affairs, and my business address is 500 West Monroe, Chicago, Illinois.
Do you have with you a document entitled Direct Testimony of Dante M. DeStefano, pre-marked as Application Appendix E, consisting of 21 typed pages of questions and answers, and 1 exhibit marked for identification as DMD-1, all of which were filed on November 23rd, 2022?
Yes.
Was this document prepared by you or under your supervision?
Yeah.
Excuse me. Do you have any corrections or additions to the document?
No.
If you were asked the questions appearing there today, would you provide the same or substantially similar answers?
Yes.
And you too have prepared a summary that has been distributed, correct?
Correct.
I'd ask that Mr. DeStefano's direct testimony be marked for identification and admitted to the record.
That motion will be allowed.
And now, Mr. Barr, we'll talk about your direct testimony. First of all, would you state your name, position of employment, and business address, please?
My name is Brian Barr. I'm the Southwest Water Company Director of Rates and Regulatory Affairs, and my business address is 1620 Grand Avenue Parkway, Suite 140, Pflugerville, Texas, 78660.
Thank you. Do you have with you a document entitled Direct Testimony of Brian D. Barr, pre-marked as Application Appendix F, consisting of 11 typed pages of questions and answers, which was filed on November 23rd, 2022?
Yes, I do.
Was that document prepared by you or under your supervision?
Yes, it was.
Do you have any corrections or additions to that document?
No, I don't.
If you were asked the same questions appearing there, would you provide the same or substantially similar answers?
Yes, I would.
Thank you. And you prepared a summary of your testimony.
Yes, I did.
I would ask that Mr. Barr's direct testimony be marked for identification and admitted to the record, please.
All right, that motion will be allowed.
Thank you. I now wish to address you about rebuttal testimony by the panel. Did the three of you cause to be filed?
Ms. Sanford, let's hold on that.
I'm sorry.
Let's hold on the rebuttal testimony.
certainly.
Until you all determine whether you're going to recall the witnesses.
Absolutely.
But then you can move the rebuttal testimony in at the appropriate time, once that determination is made.
Absolutely.
Okay.
I think I should proceed with the supplemental testimony if that's.
Yes.
Which is the.
The testimony in support of the settlement.
Yes.
Please
So-
do.
So this is addressed to the three of you. Did you cause to be filed 11 pages of joint supplemental testimony on July 31st, 2023 in question and answer form?
Yes.
Yes.
Was that document prepared by you or under your supervision?
Yes.
Do you have any corrections or additions to that document?
No.
Oh,
No.
If you were asked the questions appearing there, would you provide the same or substantially the same answers?
yes.
Yes.
You have prepared a summary, also distributed. We will ask that the panel's supplemental testimony be marked for identification as pre-marked and admitted to the record.
All right, that motion will be allowed.
These witnesses are available for examination.
All right, counsel, it's my understanding that you all have waived cross-examination opportunity of these witnesses.
Yes.
Okay. So with that, then we will proceed with commission questions. And the commission does have a few questions for these witnesses. All right. Let's see. I'm going to ask a general one just to begin with. Mr. Denton, I'm going to direct this at you, but to the extent any of you can answer, go for it. Walk me through the transaction as it's proposed, just so that I can understand exactly where the combination is going to occur, and then ultimately what's going to happen to the entity that is subject to our direct jurisdiction.
So I'll answer the last part of that question first, and then Mr. Stefano probably can talk to the details at the higher level of the organization. But the impact at Carolina Water Service of North Carolina is that there's no impact from the standpoint of overlap with Southwest Water. CWSNC will remain as it is today. I will remain president in the new organization. The organization stays exactly the same for the CWSNC footprint within North Carolina. The transaction is above that at the CII and the SW Max level, and Mr. DeStefano can talk about that arrangement.
Sure. So again, it is multiple layers up of multiple holding companies above the operating company, CWSNC. So this being a merger of equals, the way it will land is CII and any affiliates of CII will have a 50% interest in Corix US, which is an existing entity, Corix Infrastructure US, which is an existing entity under CII currently. Southwest Merger Acquisition Corp Holdco, SWMAC Holdco, will be a new entity created on the Southwest side, and that will have a 50% interest in Corix US as well. Below Corix US, there will be a new entity that's called Intermediate Newco in the application. That's an entity that doesn't currently exist. SWMAC Holdco also doesn't currently exist. Those entities will be created in the process of closing the transaction, consummating the transaction when that happens. Intermediate Newco will be a newly named entity, and we'll probably have a more formal name at that point in time. But the leadership of the merged business will be at the Intermediate Newco level. The executive team, the board members, those will be the entities or the folks that will be managing the larger business.
All right, thank you, Mr. DeStefano and Mr. Denton. So just a few follow-ups there for you. Then when the application references the combined, I want to make sure I use the exact word, combined company or combined entity. Is that reference to the Corix the Corix US entity, or is that reference to the intermediate NewCo?
It's the intermediate NewCo. That will really be the entity that will be managing the business on a going forward basis, the larger business on a going forward basis. Corix US is just kind of facilitating the 50/50 investments of the shareholders.
Okay. Will Corix US and intermediate NewCo have separate governance, separate boards of directors and officers, et cetera?
There may be some differences. I don't know if it's been determined yet what the final standing of Corix US will be as far as governance or who would be on that board. I think that's still a decision that has to come, is my understanding. But intermediate NewCo, we did explain in our application, that's been determined already who the executives and how the board will be structured. For that
Okay,
is.
so you answered my next question, because the application does go into detail about a board of directors, but it doesn't specifically identify the entity. And so my understanding is, from your testimony, is that that board of directors identified in the application pertains to the intermediate, will be the board of directors for intermediate NewCo.
Correct.
Okay. So the way I understand, or the way we understand the application, intermediate NewCo will control through its direct and indirect subsidiaries a large number of regulated water and wastewater utilities across the United States and Canada. Can you help us understand how intermediate NewCo is going to support operational management and provide regulatory and other guidance to its direct and indirect subsidiaries?
Well, I mean, all those subsidiaries are currently supported by CII as a parent company level on through to the operating companies on the Corix side of things, and similarly on the Southwest side of things. So really, we're consolidating at that parent company level, that intermediate NewCo level, and the operating companies are expected to still meet all the same obligations and requirements that they have at the regulatory level on the ground level. We do have. It'll be 20 states, 2 provinces that'll be in the combined business going forward, 5 of which we have overlap in between the Southwest and the Corix side. So we've got our established teams, and we've got our established support and resources already for those. And then over the process of integrating the entities, mostly on the administrative and general function side of things, on the corporate and support services side of things, that's where integration would be focused. And the company will look to find efficiencies and cost savings where we can on that front.
Okay, so just so I understand, prior to the consummation of integration or the completion of the integration process that will ensue, are the same, will the corporate support be coming from the same places for both the Corix entities and the Southwest entities as it's coming from right now? But prior to any sort of combination between the companies. Does my question make sense?
Yes. Are you speaking specifically on like administrative and general kind of corporate support
Yes.
service front?
Yes.
I think that's a little bit to be determined depending on the integration process. We have started integration planning between the companies. We're kind of limited, I believe. My understanding is through the anti-competition or anti-collusion type acts and the Hart-Scott-Rodino process that we can only do so much pre-closing of the merger. But we have integration planning that is started and is underway that we're planning to go into full swing once we've commenced the merger. And at that point, we're going to start moving in the direction of where we need to consolidate things, where there's redundancies, all those kind of things will be sorted out and move forward in that process.
Okay. Can you all provide a summary for us of the status of regulatory approvals for this particular combination and that you all have to achieve in other jurisdictions?
Yes. I believe we filed about 19 jurisdictions for regulatory approvals between the U.S. and Canada. As far as local jurisdictions, there's also some federal filings at the Canadian and U.S. level. I mentioned Hart-Scott-Rodino, which we recently filed. I believe it's called the Council for Foreign Investment in the U.S. or CFIUS filing that we've already completed. And there's some other federal filings as well. But as far as local jurisdictions, we've received approvals in the majority of our applications already. We have a few states or jurisdictions still outstanding, including 2 jurisdictions in British Columbia, New Jersey, Pennsylvania, California, Texas, and the current jurisdiction.
Okay, thank you. The application makes a commitment to no involuntary layoffs for the first 12-month period. I'm assuming that 12-month period runs from the consummation of the transaction 12 months forward.
That's
Um,
correct.
Do you propose, I mean, does that proposal or does that condition remain in effect? Is the company still standing by that commitment?
Yeah, all the commitments that we made in our application that aren't already subsumed in any of the regulatory conditions in the settlement, the companies still commit to going forward.
Okay, thank you for that testimony. Once the 12-month period runs, what criteria will be used to determine if layoffs will be made and which employees will be perceived as being redundant?
I think a lot of that will still have to be sorted out post-merger in the integration process. I think that's why we have that window where the companies can look and see what the process of integration would be, the time of integration. Integration of the companies is going to take some time. It's going to take probably several years to get through all the different steps of it, of all the different moving parts between different departments, software, facilities, all the different things that are going to be looked at in the integration process. So that process will take, again, several years. As far as locally in North Carolina, though, again, with no overlap operationally, as Mr. Denton said, there's not anticipated to have any impact on North Carolina staff.
Okay, just following up on that last point, just so the record is clear and I'm clear. One of the things that let me speak for myself, routinely hear when we're out in front of your customers at public hearings is their appreciation for the Carolina Water Service staff that works out in the field, that shows up to fix their problems, to help them navigate through whatever the situation of the moment is. And that is that always sticks with me. I can remember specifically being at one hearing where a customer pointed to Mr. Denton and took issue with the suits. He referred to you all as the suits, but said the guys in the field, the women and men in the field are helpful and provide wonderful service. What can you tell me about those men and women who are in the field in North Carolina providing service to your customers, helping your customers when they need it? Is anything going to change with respect to those men and women 12 months after this transaction is consummated, assuming you all receive all the approvals you need?
Yeah, I can talk to that, Chair Mitchell. We do not foresee anything that is a workforce reduction along those lines. I mean, in fact, as we've stated in testimony, we want to grow and continue to grow. We think consolidation is the right thing in North Carolina, which would actually mean that we would be adding staff in order to facilitate that growth. And so I see just the opposite. Retention of employees and development of employees is a big focus for us right now. It's hard to find qualified operators in the current market, and we're doing everything we can in order to keep the good people we do have and find new ones.
Okay. Thank you for that testimony. Mr. DeStefano, you've talked some about the integration process that has perhaps begun and will continue, assuming you all move forward. Have you all given any thought to or done any analysis of the costs that the companies are going to incur to achieve integration?
There's been some analysis on that. I guess it kind of comes depending on where we're at in the process and where the bigger issues or bigger topics are versus the smaller topics is my understanding. We provided some information in discovery as well about, for example, ERP system consolidation, and that would take place over the course of multiple years as we integrate different jurisdictions into the new software and get everything fully on board. So we identified some costs related to that and offsetting benefits as well in that process. So we're trying to look at both sides of it as far as costs and resulting benefits that would happen from each integration process.
Well, you anticipated my next question was help me understand the functional areas where you all will be able to achieve some savings. But before we get to that question, you mentioned software or software programs. Again, assuming this merger goes through, will Carolina Water, will the Corix companies have to be converted to a new type of software platform or platforms?
I can touch base. There are a number of decision points, both operational technologies and IT, that we're looking at that would be a part of the integration process. There has been a decision to move forward with a new ERP platform in the integration process. However, we've looked at the timing of that, and actually, at least from a planning perspective, trying to make sure that that timing doesn't conflict with, let's say, timing of anticipated cases, such that we don't end up with an issue where we're going through a transfer of technology at the same time we're needing to respond to DRs and commission requests.
Okay. It's good to hear that you all are cognizant of issues that may arise in such a situation and paying attention to that.
Yes.
All right. Let's see, the affiliate agreement. We have some questions on the affiliate agreement. When would you all expect to propose changes to Carolina Water's affiliate agreement?
I think that's another item that's still to be determined. We're still working through, again, as part of integration and beginning those conversations, how cost allocations would work, how our cost allocation manuals may currently be the same, differ, how they would accommodate the current or the new organization versus the current organization. We're starting to have those kind of conversations currently. But at the moment, we don't anticipate any near-term filing for a change in the AIA.
Okay. So is it premature then for me to ask you what would change in the affiliate agreement?
Yeah, I think that would be, we're not quite there yet.
Okay. All right. Carolina Water has provided good service to customers here in North Carolina for decades, and has performed adequately and provided beyond reliable service to its customers for many, many years here, and has stepped in to be an emergency operator when called upon to do so, when asked to do so, and has provided good service to those customers who were in an emergency situation. Do you anticipate with this business transaction that Carolina Water's willingness to participate as an emergency operator when called upon, or to step up and make investments in its system when they're needed to ensure the provision of adequate service to its customers, is going to change as a result of this transaction?
I do not see that changes at all. In fact, we share a common philosophy with regards to that with Southwest Water, that at the request of the state, we're willing to step in and support the needs as requested. So I do not foresee that changing as we move forward.
Do you anticipate any change in Carolina Water's view of itself as an important partner in the provision of water service to customers in North Carolina as a result of this transaction?
Only in an increasing manner.
Okay.
We're an increasing component of that in the state as we continue to grow.
Okay. Do you anticipate any change, Carolina Water's perspective on consolidation of systems growth in North Carolina, acquisition of systems in North Carolina as a result of this transaction?
None whatsoever. We continue desire to grow in this state.
Okay. All right. Let me see if there are questions from other commissioners. Go ahead, Commissioner Duffley. Oh, I'm sorry, Commissioner Brown-Bland.
Mr. Denton, I just want to know from CWS's perspective and then yours, as it impacts you, your leadership, what will change or be different for you in the job you're currently doing if this combination's approved?
Well, as president, and at the local level, I don't see a whole lot changing for the team. I see that there is an opportunity as we bring in access to new states and new personnel, that provides, quite frankly, diversity of operational experience. And that is something that actually will benefit us. Also brings more depth from a bench strength perspective. that will benefit the state, for crisis management, hurricanes, you name it. And so we think that that is a significant benefit, but on the day-to-day operations, we don't, obviously in North Carolina, we don't have an overlap, so we don't see a whole lot changing day to day.
Okay. And after if the commendation is approved, you'll ultimately be reporting to the new co.
There's a new COO that will be put in place. Rich, who is currently the COO of Southwest, will be the COO of the new NewCo. I will report directly to Rich. My role changes a bit, that I am currently not only president of Carolina Water, I'm also president of Blue Granite in South Carolina and SVP of the East Region, which includes the president of Florida reporting into me. That shifts in the new co. I will be the SVP of the Northeast, but only president of Carolina Water. And so there are two presidents in the Northeast that would report to me, but they would have responsibility for those jurisdictions and report to me in the new structure. I would be president only of North Carolina. I will no longer be president of South Carolina.
And so, and just following that, so what aspects, and again, this is to you personally, when you learned about this or you knew it this possibility, what aspects of your day-to-day do you expect to be different?
Well, other than
You go to the office and do the same thing?
Oh, no, yeah, I expect to be doing a lot of the same thing. To be honest, I'm dealing with a few different people, quite frankly, but I think the day-to-day is exactly the same. I'm excited about the opportunity that it brings from the standpoint of having been through a number of mergers on the electric side and seeing what it can produce. The culture of these two companies is very similar. And in the past, I've seen some cultural differences that led to challenges in integration. I'm excited for this opportunity because of how similar these two cultures are.
Yeah. Thank you.
All right, Commissioner Duffley.
So my question is to Mr. Barr. We heard Mr. Denton testify about emergency operator philosophy and that Southwest shares the same philosophy as CWS. And I just want to hear your testimony on that point. Do you agree with Mr. Denton's testimony?
I agree with it completely. And I appreciate the opportunity to respond to that. Southwest operating companies take a lot of pride in being a resource for the commission and able to provide that service as an emergency operator. Currently, we're emergency operator for, within the past 5 years, 3 systems, specifically in Texas, that have been very troubled. And the commission has reached out to us to serve as the emergency operator of those systems. And so we take a lot of pride in that.
Thank you.
Good morning, gentlemen. Appreciate you being here and sharing the testimony you've provided. Just a couple of quick questions. I know there's been a commitment made that for Carolina Water Service, you're not going to go out and terminate any employees for a 1-year period. Now, I also see language in this stipulation relating to any type of change in control payments made to terminated executives, merger-related bonuses, incentive payments, retention payments, severance payments, and those type of things that would not be passed on or to Carolina Water Service customers, to that company in any respect. Do you anticipate those changes will take place with the entities that you're merging with? Or is that just a catch-all provision that's put in there just for protection, or what is anticipated to change, since that language is pretty precise?
I think we wanted to make sure that the language there was precise so that we can make sure we're drawing a firm line as to what we're talking about there and make it clear as far as from interpretation perspective in the future, that we know really what's not in play for passing costs on to customers. We're really focusing in that section on what costs are related to the transaction and related in the process of consummating the transaction, to getting across that. And the company's committed to not passing those costs on, to carving those out from passing anything on to the customers.
But do you anticipate that any of those provisions would actually be triggered with the entity that Carolina Water Service is being merged with? Or is it just there just for protection?
I think it's just there to be maybe more comprehensive to your point.
Okay, that's good. And of course, there is language here about Carolina Water Services may seek to recover costs related to merger savings, in the future. What type of merger-related savings are reasonably anticipated at this time?
Again, we've kind of just kicked off the process of looking at all the different integration pieces that will be coming. What we identified, and we gave some information discovery on this, we identified it, I believe, in direct testimony in the application, is obviously we're going to merge 2 boards of directors, 2 executive teams, and kind of those higher level teams will be merged into one. Those costs, which are currently being allocated down, to our respective kind of towers or separate companies, would be allocated down in the future to a combined entity. So you're talking about one executive team spreading across a larger base of operating companies. So there should be savings that would relative to the current state for the operating companies. That's one example we've identified.
So that would be the type of cost that could be reasonably anticipated that might be passed on in a rate case in the future.
Well, speaking on that piece particularly, those would be benefits that would be savings that we would get from the larger scale and the larger company that we would have going forward with the single executive team, single board. So relative to the current state, there would be anticipated savings to customers that would trickle down from that corporate change to the operating companies.
And as I recall, there's language there saying that if there is like a director change, an officer change, there'll be notice provided to the public staff.
That's correct.
That's correct. For key position changes, there'll be notification. That's right.
Now, let's say within Carolina Water Service itself, there's organizational changes. To what extent will they be reported?
I believe we've committed to that director of operations, the head of FP&A, our regulatory personnel, that level, we've agreed to report that as well to the public staff.
And that would be in advance of those changes or after the changes?
After, but I believe it's 10 days. After.
Yeah, very promptly after.
Very promptly after.
Yeah.
In certain circumstances, we just couldn't do it beforehand.
Okay. And there's language here dealing with the cost allocation manual. Do you anticipate there will be changes to the cost allocation manual as a result of this proposed merger?
At this point, we're anticipating there will be changes, but we don't know what those are. Again, still working through that process. Public staff's obviously gotten copies through rate cases and everything else of our current manual, so they're familiar with it. But yeah, to the extent there are changes that happen in a normal course through the merger or even other major changes, the provisions here cover that.
But you have no idea what those changes would be at this time?
Not yet. We're not there yet.
Okay. And there was language about developing a customer assistance program.
Yes.
There's also language in there saying that the costs associated with development and funding of the CAP shall not be included for recovery by Carolina Water Service in any future general rate case or rider proceeding. Is that correct?
That's correct.
Right.
Let me ask you this. Have much thought been given to this potential customer assistance program and what it might consist of? I do see some parameters that are included, but is there any type of a model that you're hoping to replicate that's being successfully implemented by entities that are under your control that might be in other jurisdictions, or ones that may not be under your control but are successful models for customer assistance programs?
Yeah. So I guess, again, another instance where the merger, I think, benefits us is Southwest has experience in multiple jurisdictions, especially California, where customer assistance programs are a big focus and have been established for a long time. So there's been a lot of data you can kind of glean from those experiences since they've been around so long. We have been approved in other jurisdictions like Illinois and Pennsylvania for lifeline rates to be put into effect. So we've got recent experience with that in other jurisdictions. We've also made proposals of different types, like a roundup program in South Carolina in our last rate case there. But when it comes to customer assistance programs, there's a lot of new data, a lot of entities, municipalities, companies are trying a lot of different things out, and there's a million different ways to kind of do it. So we want to make sure we put together a proposal that is going to hit some key marks, that's going to be administratively efficient, because that can eat away at the benefits of the program very easily. And that it's easy for customers to, as easy as possible for customers to apply and be approved for. So it's a low burden for customers as opposed to just the company administering it. And that we can get as many people that need help to get help from the program. So as long as we can focus on those priorities and we can try to establish a program that hits those marks, we think it can be a successful process.
Thank you. I don't have any further questions.
All right. Mr. Barr, just one for you. What can you tell us about why Southwest wants to be in North Carolina?
Chair Mitchell, I guess I'd respond to that by saying you yourself actually just recently said that Carolina Water has provided service for decades and been done at least an adequate job of that. And so for Southwest Water, I can't reiterate enough how much that this is a very complementary transaction of two entities that are very similar in terms of mission, values, and so I think North Carolina is regarded as an excellent state, and that specifically Carolina Water Services as a component of Corix overall is a very well-run operation and very good business and very, very attractive.
All right. Thank you, Mr. Barr. Anything else from commissioners? All right. With that, you all may, let's see if there are questions on commissioners' questions before I let you go.
No questions.
Okay.
No questions. Thank you.
All right. Well, with that, gentlemen, you all may step down and to be determined as to whether you're excused.
Thank you, commissioners.
Thank you.
All right, Ms. Culpepper.
Public staff calls Lynn Fiesel, Lindsay Darden, and John Hinton.
All right. Good morning to the three of you. If you would, please raise your right hands, left hands on the Bible. Do you swear the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. Please proceed, Ms. Culpepper.
Ms. Fiesel, please state your name, business address, and present position for the record.
My name is Lynn Fiesel. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I am the Public Utility Regulatory Analyst Supervisor of the Water, Sewer, and Telecommunications sections with the Accounting Division of the Public Staff and the Utilities Commission.
Ms. Darden, please state your name, business address, and present position for the record.
Lindsay Darden, 430 North Salisbury Street, Utilities Engineer with the Water, Sewer, Telephone Division.
Mr. Hinton, please state your name, business address, and present position for the record.
My name is John Robert Hinton. My business address is 430 North Salisbury. I'm the Director of the Economic Research Division from the Public Staff.
Ms. Fiesel, on June 30, 2023, did the panel prepare and cause to be filed in this docket joint testimony consisting of 15 pages, 3 appendices, and 1 exhibit consisting of 8 pages?
Yes.
Does the panel have any corrections to its testimony?
No.
If you were asked those same questions today, would your answers be the same?
Yes.
Chair Mitchell, I move that the joint testimony consisting of 15 pages and 3 appendices be copied into the record as if given orally from the stand.
All right, Ms. Culpepper, my notes indicate 4 appendices. I just want to make sure we're clear on the record. Is it 3?
3.
Okay. All right. Your motion will be allowed.
I also move that Public Staff Exhibit 1 be identified as marked and filed and entered into evidence.
All right. The exhibit to that testimony will be marked for identification as it were when pre-filed, and having heard no objection to your motion, we'll admit that evidence into the record at this time.
Thank you. Ms. Feasel, on July 31, 2023, did the panel prepare and cause to be filed in this docket joint settlement testimony consisting of 12 pages?
Yes.
Does the panel have any corrections to this testimony?
No.
If you were asked those same questions today, would your answers be the same?
Yes.
Chair Mitchell, I move that the joint settlement testimony consisting of 12 pages be copied into the record as if given orally from the stand.
All right, that motion will be allowed.
A testimony summary has been provided to the commission, court reporter, and the parties,
All right, thank you, Ms. Culpepper.
and the witnesses are available for commission questions.
Okay, just for the record, the parties to the proceeding have waived their opportunity for cross-examination of these witnesses.
Yes.
Okay, so we will move then to questions from the commissioners, and I will start. You all, the three of you all have been in the room the whole time this morning, is that correct?
Yeah.
Make sure
Yes.
okay.
Yes.
And did you hear the responses provided by witnesses for the applicants to the questions that they were asked by commissioners?
Yes.
Yes.
Okay. Is there anything that you all would like to say in response to any of the responses provided by the company or by the applicants? I'm sorry.
I don't have objections, just to make supplemental comments for some of the questions. For the first one is related to, does the company anticipated any merger-related costs? And so for that one, we put that on item 1 of the regulatory conditions. So we are trying to hold the repairs harmless from any potential costs that incurred because of this merger. Because had this merger not happened, this cost would not have incurred. So we put that here, the repairs will not pay the cost related to the merger. So that is my comment for that question.
Thank you, Ms. Feasel.
I could possibly add to that, to one of the questions I was asked about the benefits that I think Mr. Denton responded to. But the one that focuses on me is protection against debt, a decreased credit worthiness. I'm gonna go back a little history as I do so often now. Commissioner Caulfield about 6 years ago, or maybe 5 years ago, asked the analyst from the Economic Research Division about the high cost of debt of Carolina Water. And the analyst responded it was reasonable. He could have better said it was not unreasonable. There is a history of Carolina Water having a high cost of debt relative to Aqua and now Essential Utilities. It's largely due to one particular issuance that they did years ago, 6 5/8 interest rate, and it has a lot of prepayment provisions that make refinancing not attractive for the companies. When they do, they may make whole economic analysis. It's not worth economic to refinance that loan. It's always been a burr in my saddle. You can see it in the embedded cost of debt that we approved for Aqua and Carolina Water. And there's a 50 to even a higher basis point differential between those two companies. And that goes right to the ratepayer cost. So it hits me personally. They are open to, they've agreed to a condition that will, in a couple of years, go through an economic analysis, see about a public issuance to have their stock publicly rated. That's, of course, not a free item. That costs money. Fees are paid to S&P to do that evaluation. It needs to be done. I agree. It needs to be done post-merger to get a more full picture of the economics of the merger. And they've agreed to this. And I think that's worthwhile because I hope that process of public issuances, they'll be in a better position to have cost of debt that will be more akin to what Aqua America has today on its books. Again, it was a private placement done years ago with some teachers union, and that it was a costly issuance. At that time, it may have been reasonable, but the fact that it had these prepayment penalties or provisions, I think have been costly on our ratepayers because I would have preferred that debt to be retired a long time ago. There are other provisions in the order that we feel, I mean, in the conditions we feel appropriate. But that one was particularly strong to me because it goes to the heart of the future environment where a bigger pool of investors will be available to bid on a debt issuance by, then it'll be CIA, immediate new code. and the corporate general entity that'll be issuing the debt, which will be a combined structure. Or it'll have they'll have relationship whenever anyone issues debt, their rating will be cognizant of the parent entities. So this merger, even though the debt may be issued under a Corix headline, it'll have an impulse, it'll have an influence to do with the merger we're approving today.
Okay, thank you, Mr. Hinton.
I was going to add about the testimony that was given on the customer assistance plan, just that the public staff agrees with the philosophy that Carolina Water has, focusing on that it be administratively efficient and easy for customers to apply and help serve as many customers as possible. We know this is still in the infancy stage of planning, but just that we've discussed and our philosophies align with what Carolina Water shared with us so far. And then one more about your question that you had about the actual men and women who are operating the systems. That's something that we discussed too, and that's why we have the red condition number 36 about, we know that this is an industry-wide problem of companies retaining and keeping good operators, and it's Carolina Water will be working with providing a report as to document their work on that and their initiative on keeping the same concerns that you had mentioned too.
All right, thank you, Ms. Darden. All right, one follow-up, Mr. Hinton, for you on the issue of public issuance. So I've reviewed the proposed reg conditions and in particular, the one of which you speak. And my question for you is this: how likely is it that, assuming the transaction were to be consummated as it's been proposed and as it's contemplated, that the public rating would be able to be achieved?
I think it's quite reasonable. Again, they'll look at it, the cost of being publicly rated, they'll look at the benefits, and we can review that decision through this process of meeting with the company on a regular basis. Southwest Water is publicly rated. I believe they issued mainly through, again, private placements, but apparently at one time in the past, they may have had a public issuance that was for debt. So, and at one time they were a publicly traded company, and maybe that's when it goes back to. But I remember the first meeting we had with Southwest Water on the merger, and they acknowledged that they were publicly rated. I talked to the finance person at that time. So I think to answer your question, I think it's very possible because they'll be combined together. Even though they may issue debt separately, they may issue. You don't know how companies will evolve over time. And all dollars are green, as I've testified to in the past. So you don't know how when they issue the debt, the bond person who lends them the capital will be aware they're owned by their ownership is shared with Southwest Water. So I think it's very possible.
And can you, just for my own edification, which entity would achieve the public rating, assuming the transaction occurs as it's contemplated?
To be honest with you, I would assume it would be the Corix up, or the Corix down, possibly, or maybe in whatever intermediate new code eventually turns into. I mean, that name will not last forever, I expect.
Okay. All right. Let me see if there are questions from other commissioners. Commissioner Brown Bland.
Just one of a general nature. Has the public staff, in thinking about this combination, identified or seen that there would be any either additional efficiencies or additional levels of work created by the fact that you would now be overseeing the merged company, either for the public staff or the commission? What change do you see? Or is it going to be, non-transparent to us? It'd be just same as we now see with CWS. Well, the current Corix. Yeah.
On a capital level, largely be transparent.
I would assume the same for on an operational level too.
The same.
All right, thank you.
Commissioner Kim Wright.
Good morning, Mr. Hinton. Following up on Chair Mitchell's questions about, believe it's the regulatory condition 7D and dealing with about the company evaluating accessing debt capital through publicly traded debt instruments. And that regulatory condition states that the company's to evaluate that within 36 months after the transaction. Can you provide some information about how the 36-month period was determined?
Yes, originally I wanted something less, but the company argued that, and it was persuasive, that, like I alluded to earlier, that when S&P would likely be the person who would rate this company because they do more small orders than Moody's does, which tends to focus on the Duke Energy of the world. They would want to look at the business operations or financial operations of a combined entity over time. And these ratings are obviously never done in a vacuum, and financial benchmarks only take place about 40 to 50% of the weighting of a complete evaluation. So they want to see if there are some shared economics, which we believe there should be and can be. So I think 36 months was a reasonable compromise because it made some sense.
Okay. And then, Ms. Darty, my last question deals with regulatory condition, I think 36, about providing annual reports about efforts to develop and retain qualified operators. Is CWS experiencing any difficulties with retaining qualified operators that are in excess or different from the other water, wastewater utilities? Are their challenges greater or different?
The public staff's understanding is the challenges are the same, that it's something that a lot of companies are struggling with now. It's apparent there's more contract operators that have been used just because of the shortage and retaining those employees. But it's kind of an industry-wide issue.
Thank you.
All right, any additional questions from commissioners? Questions on commissioners' questions?
No questions.
No questions.
Okay. All right, with that, you all may step down and you're excused. Thank you very much for participating this morning.
Chair Mitchell, I need to make a correction to what I stated earlier. There were 4 appendices.
Okay,
One was for Ms. Chu, who was excused.
okay. The record will so reflect that there were 4 appendices to the public staff's joint direct testimony.
Thank you.
All right, at this point, would it be helpful to take a 5-minute recess?
Yes.
Okay, we will be in recess until 10 after 11. Let's go off the record, please.
Thank you.
All right, CWS, or the applicants, have you decided to recall your witnesses?
Yes, we have, please.
Okay.
We would like to recall the panel, and as they're coming up, we've discussed this with the public staff. We would like to get the rebuttal testimony admitted, and then we would like permission to ask two very brief clarifying questions.
All right,
And we've vetted this with the public staff.
understood. All right. Gentlemen, just a reminder, you're under oath.
Let's see. We're talking about rebuttal testimony at this point. This question is to all three of you. We will let you decide who answers. Did you cause to be filed on July 14th, 2023, 29 pages of joint rebuttal testimony in question and answer form and one exhibit?
Yes.
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 All right, well, everybody can answer. Was that document prepared by you or under your supervision?
Yes.
Yes.
Do you have any corrections or additions to that document?
No.
If you were asked the same questions, would your answer be the same or substantially similar?
Yes.
Yes.
You prepared a summary. We distributed that earlier. We'd ask that the panel's rebuttal testimony be marked for identification as pre-marked and admitted to the record. Please.
Hearing no objection to that motion, it will be allowed.
Thank you. We also are asking for leave to ask two additional questions. Bear with me for 1 second. Let me find my questions if you've got them. And these are just questions for clarification based upon other testimony this morning. We want to be sure that the questions are that the answers are jointly understood.
All right, I will allow that request.
Thank you very much. Is Southwest publicly rated?
Just to ensure clarity of the record, Southwest is privately rated, Southwest Water Company.
Southwest Water Company, privately rated. Okay, thank you very much. And secondly, could you describe the commitments in 7A and 7C, that's reg conditions 7A and 7C, with respect to ratings?
Yes, so the parties have committed to analyzing creditworthiness and maintenance of the capital structure profile and investment grade profile for intermediate NewCo in A and CRU US in C. The last line of each, though, clarifies that the companies, those entities are not committing to get rated, publicly or privately rated, but that this process is allowing for an analysis of creditworthiness without a rating.
Thank you. We have no more questions.
All right, let me see if there are questions from commissioners. Okay, just one clarifying question. Mr. Barr, you said Southwest Water Company. Where, just get me oriented on the org chart. I'm sorry, not on the org chart, but on the figures 1 and figure 2 included in the application. Or where is Southwest Water Company on those, within those entities identified on those
Approach.
you may go ahead.
Here, I've got it right here.
Figure 1 and figure 2. On figure 1 and figure 2, the boxes denominated regulated utilities. That's where Southwest Water would be.
Okay. Okay. Did you all hear the testimony given by public staff witness Hinton regarding Carolina Water's cost of debt?
Yes.
Can you respond to the concerns expressed regarding high cost of debt relative to the other large water, wastewater provider in North Carolina?
Yeah, as Mr. Hinton noted, we have existing cost of debt that we've maintained over time. In recent years, we've had new cost of debt this is all at the CRU US, Corix Regulated Utilities US level, which is the direct parent of CWSNC. New debt has come in as interest rates have dropped, and we've had new issuances that have lowered our overall cost of debt substantially in the past several rate cases. In going forward, as mentioned in Ms. Lapson's testimony, we anticipate having a broader range of debt providers available to the company as we merge and pool our resources. And then we should be able to facilitate lower cost of debt going forward than we currently have, or than we would have otherwise, excuse me, without the merger.
Okay. Thank you for that testimony, Mr. DeStefano. Just one follow-up there. I heard Mr. Hinton testify as to certain terms of that high-cost debt, that an older placement that the company has not been able to refinance as a result of certain terms on that issuance. Did you all hear that same testimony?
Yes.
And as I understood his testimony, there's a buyout provision that makes refinance uneconomical for the company. Did I understand? Did you all understand his testimony the same way I did?
Yes, there's a make-whole provision on that particular issuance.
And is that in issuances in which the company has participated post that particular high-cost transaction, just to identify it so we understand what we're talking about? Are there similar terms on issuances that have occurred since that high cost?
To my knowledge, no, but I'm not 100% sure about that. I know that's the one that has come up again from Mr. Hinton's testimony and rate filings and so forth. So that's been the focus as opposed to the other issuances.
Okay. And what I understood your testimony this morning to be that post that high cost issuance, the company has engaged in subsequent issuances that have been at lower cost. Is that correct?
Correct. They've been, yes. And just to clarify, that initial issuance, or that the first one we're talking about, was in 2006, and we've supported that was a reasonable cost at the time based on the market conditions at the time.
And okay, understood. All right, I just want to, the way I understand your testimony today, Mr. DeStefano, is that the transaction for which you all seek approval would allow the combined company to access a larger pool of issuers. Is that correct?
Correct. That's how Ms. Lapson supported that in her testimony in this case, yes.
And do I understand your testimony today correctly?
Yes,
Okay.
we agree with that.
With the potential to provide more competitive, or at least competitive, cost of debt as a result. Is that correct?
Yes, it puts us in a better position to manage the cost of debt going forward.
Okay. All right. Any additional questions from commissioners? Go ahead, Commissioner Clodfelter.
Mr. DeStefano, I remember very well the discussion about that high cost debt. I think it was 2 rate cases ago, but what I don't remember, and so I'll ask you to refresh my recollection, what's the final maturity of that debt?
I believe it's 2031, but we're paying down $9 million every year on it. So it's becoming a much smaller, again, as we have new issuances, it's becoming a much smaller piece of the total debt.
I just couldn't remember the final maturity. As I recall, though, the make-whole provision doesn't terminate any sooner than final maturity. So you carry that millstone all the way to final maturity.
That's
right?
my understanding, but we do regularly reevaluate it to see if our position or economics of it have changed.
You do?
We evaluate, because the make-whole provision depends on the market conditions. So
Right.
we do reevaluate it periodically to see if it.
Or can you defease that debt? If market conditions should support a substitute issuance, could you defease it? Or does that trigger the make-whole also?
Well, I would have to refer to the agreement on that, not quite sure.
It's not that critical. I just thought you might have the details off the top of your head. Thank you.
All right, let's see if there are any questions on the commissioner's questions, or on the Ms. Culpepper, specifically on the 2 additional questions that Ms. Sanford asked of the witnesses.
No question.
Okay. Questions on commissioner's questions?
No questions. Thank you.
Okay. All right. With that, then, gentlemen, you may step down. Thank you for your participation in this proceeding and for being with us this morning. All right, we have come to the conclusion of this hearing. Before I get to post hearing filings, any other matters from the parties?
No, ma'am.
Okay. Well, we'll call for post-hearing filings 30 days from the notice of issuance of the transcript. You all may file them as early as you'd like, but no later than 30 days. And with that, we will be adjourned. Thank you very much.
Thank you.
Thank you.